переключиться на режим русского языка. И при этом вы можете оставить фоновым английский язык, чтобы слышать их оба, или заглушить английский язык и слушать только русский. Thank you. And what else? I want to say thank you to our sponsors, informational sponsors, who help us to organize this event. And this is Tanyana Informational Agency, certainly Moscow Chamber of Commerce, Kaliningrad Chamber of Commerce, Digital Agency Exeter, and the Targum translations from United States. So, and now we have to move forward and to present our next speaker. And I think his topic would be as well very interesting, because after what I heard from Nadezhda, the difference in the litigation between Russia and United States in IP is huge. Thousands of kilometers separate our countries, and thousands of cases separate our judicial systems, because it's hard to imagine to have a jury here for IP case. We still don't have them for most of the criminal cases, and it's hard to imagine to have them here. In some small city, like not in Texas, but in Krasnodarsky district, somewhere nearby the Black Sea. So that's why I want to introduce our next speaker, and his name is Andrey Inshakov, and he is a head of patents in Yandex, Russia. And he will tell us about differences between United States system and European one, and maybe in small connection with the Russian one. But it would be not about the litigation, it would be about the prosecution. Andrey, we are waiting for you.
Hello, thank you, Dmitry. Just let me share my presentation with you, and we can start. Okay, so good evening, dear colleagues, dear audience. It is a great pleasure to be speaking here today. As Dmitry mentioned, my name is Andrey Inshakov, and I work with patents at Yandex. The topic of this webinar is entering the US, right? And I will be talking about the differences in patent systems of the US and European Patent Office. And the reason why I chose this topic is that I want to show how the US is different, not just from Russia, but from a lot of countries in the world. And the EPO, being an international organization, covers a lot of developed and developing countries, mostly European countries, but there are also non-European countries among the so-called validation states and extension states, where European patent can also be made effective. And although each country in Europe does have its own national patent office, the approaches to patents there are generally similar and correlate with what EPO does. And besides, many approaches that and concepts that exist in EPO are similar to what we have here in Russia. So this presentation is sort of a brief summary of things to pay attention at if you are thinking of patenting your innovation in the US. Let's start. Let's begin with general characteristics of the US and EPO patent systems. First of all, the United States is a common law jurisdiction. Therefore, precedents play a major role there. There is a patent law, which is codified in Title 35 of the United States Code, and it does contain a lot of important rules. However, most of them are quite broad and often require additional extensive interpretation, and sometimes they're simply not sufficient. Precedents, on the other hand, provide this additional guidance and interpretation and of the provisions of the law, and set additional requirements for obtaining patents. In the US, the patent practice is reactive and sometimes changes quite fast in response to new presidential decisions of the courts. And in a setting like that, we always have to we operate with within a certain degree of uncertainty, high degree of uncertainty, because we never know what precedential decisions will appear in 2 years, in 5 years, in 10 years, and we never know how the patent granted today will be viewed and construed by the courts in future. On the other hand, EPO is completely different. It is based predominantly on civil law, and the main statutory source there is the European Patent Convention. Precedents have very limited role in the EPO. I think the closest EPO has to American precedents are the decisions of the Enlarged Board of Appeal, which are relatively infrequent. So this is a stable jurisdiction. Patent law and practice are stable and change relatively slowly. Let's move on to patent eligible subject matter, or in other words, what can be patented there. In the US, paragraph 101 of the 35 USC sets 4 categories of patentable subject matter. And those are process, machine, manufacture, and composition of matter. And this list is exhaustive. And although the law does not define any exclusions, precedents over time have set up, developed 3 exclusions: abstract ideas, natural phenomena, and laws of nature. And this process is of defining what actually could be categorized as falling into those 3 categories is still going. So this is not something that is set in stone. So it may happen that in a year or 2, there will be new cases that will tell us more about what abstract ideas or laws of nature are. And EPO, on the other hand, does not define any categories of patentable subject matter. European Patent Convention simply says that any technology, any invention can be patented in any area of technology as long as it complies with 3 criteria, right? Industrial applicability, inventive novelty, and inventive step, pretty much similar to what we have here in Russia. And Articles 52 and 53 of European Patent Convention define a relatively large list of things that are excluded. I will not read them all, but I want to say that those things are very similar to what we have in Russian Civil Code, right? Let's say Article 52, which defines matters which are considered as such not patentable, is almost a word-by-word copy of the corresponding provisions in Article 1350 in Russian Civil Code. So claiming, there are differences in claiming style. In the US, the claiming could be described as fence style claiming. And what it means is that typically claims are written as broad as possible and as short as possible, as long as prior art allows that. Usually there's no division of the claims into 2 parts, prior art and improvement. And claims are written in order to set up a fence around a broad field of things, the use of which the applicant wants to prohibit to others. And let's say the applicant can use very broad terms in the claims, and later those terms and the claims themselves will be construed in light of the description. Basically, the court will go and look at the description, the examples, and definitions present in the description to determine what each term in the claim means. So in practice, that means that the description of the patent is as important as the claims. And EPO is different. EPO in this sense is similar to Russia. EPO tends to favor the what could be described as point style claiming, right? The EPO prefers two-part claims divided into prior art and in improvement parts. And this is not mandatory, but they prefer to do so. And this is the approach that is relatively frequently used by Russian patent agents as well. And there is a clarity requirement. Which says that the meaning of the claim must be clear for the person skilled in the art from the wording of the claim alone. That means without referring to the description. And in practice, that leads to a narrower scope of patent protection. So it will not be an exaggeration to say that for the same invention, the scope of patent protection that you can get in the US can often be broader than what you can get in the EPO. Prosecution. There are differences in prosecution. In the US, there is a 1-year grace period that is applicable in relatively wide range of situations. Grace period is basically a time frame after the disclosure, the public disclosure of the invention made by the applicant, during which the applicant still can still file patent application, and that disclosure will not be considered prior art. There are, second thing, there are provisional applications, which are sort of preliminary applications, like beta version of applications, which can be filed and within a certain period of time could be turned into regular application upon applicant's request. And that could be used, for example, if there is no time for some reason to draft a full patent application, or if the applicant does not know whether he or she will need a patent and but still wants to claim priority to get the priority date. Also, the prosecution can be extended in the US, can be extended virtually endlessly through filing a specific request, which is called the request for continued examination, and paying a relatively high fee for that. Also, there exist continuation applications, which basically can also prolong the prosecution. So as long as if the applicant wants to continue, the applicant can file RCEs, pay fees, and continue that process and relaunch it as many times as he or she wants. In the EPOs, the situation is quite different. There is a 6-month grace period, which is applicable in very specific and rare situations. And those situations are an evident abuse in relation to the applicant or his legal predecessor. And the second case is the display of the invention at an official or officially recognized international exhibition, and not just any exhibition, but the ones that are falling within the terms of the conventional international exhibitions. And those are rare. Those are very rare cases. So if you're thinking about patenting in the EPO, you would be safe to think that there's no grace period in Europe. And if you're thinking about it, then make sure not to disclose your invention before filing a patent application and establishing priority date. Typically, prosecution in the EPO is closed after the decision to refuse is made, and that could be appealed to the Board of Appeals. Claim amendments, the rules of amending the claims are also different. In the US, the rules to claim amendments are relatively loose. And claim amendments can be based on the description and the figures. And if the specification has a lot of examples and alternatives, virtually any claim amendments encompassing the combination of these examples is possible, even if that specific combination of claim elements is not explicitly disclosed in the description. EPO, on the other hand, has very strict rules on amending the claims. Claim amendments must unambiguously follow, and unambiguously is an important word here, from the description. There are strict rules to selecting variants from claim amendments among the ones disclosed in the description. And the applicant cannot combine claims if that specific combination is not disclosed in the description. And now moving to my favorite part, enforcing and challenging patents. And as Nadezhda and Casey told us today, enforcement in the US has a lot of unique features that may be surprising for people from other countries. And I will not go into further detail, but there are jury trials. Jury trials in patent cases are very often, and it happens often that judges, jurors, and lawyers often don't have technical background, and that leads to, and what it could be surprising to people from other countries is that in a situation like that, issues of great technical complexity are evaluated and decided upon by people who are very far from being specialists in that respective technical area. And as to the challenging, to invalidating patents, there are several routes through which patents could be invalidated. Some of them are relatively old, and some of them are newer and appeared after the changes in legislation that happened in 2011, which is known as the America Invents Act. And there are 4 options: ex parte re-examination, post-grant review, covered business method review, or CBMs they're also called. There's inter partes review, or IPRs. And comparing to many other countries where typically there's only one route to invalidate the patent, US offers a pretty broad selection of options. And in the EPO situation is different. As I said, EPO is an international organization that basically performs the examination and grants patents that could be validated in European countries. So almost all questions of patent validity, as well as the infringement, are decided on national level, separately in each country where the patent is validated, where the patent is active. And some of the countries have specialized patent courts, and some of the countries have judges with technical background, as for example, Germany. And here in Russia, we also have those in the court of, in the intellectual property court. And there's only one mechanism of challenging a patent at the EPO level, and that is the procedure of opposition, which could be executed within 9 months after the publication of the decision to grant was made. And companies which operate on the European market use this mechanism quite often, because it is easier to invalidate one patent than just to fight, let's say, to invalidate 5 patents in each separate jurisdiction. And last but not least, those are the concepts that I personally find fascinating about the US patent system. One of the most interesting ones. In the US, the first one is the doctrine of unclean hands and the concept of unenforceable patents. In a nutshell, that means that if the patent holder committed some kind of a fraud against the patent office during the prosecution of a patent application, the court may may determine that it was inequitable conduct, and that may render patents unenforceable. And unenforceable here means that regardless of whether the patent is valid or not, regardless of the validity of patent, that patent holder will not be able to sue anyone with it. So basically, even if it's valid, if the patent owner will still not be able to go to the court and to sue his competitors, let's say. And what kind of fraud could it be? Well, I think the most often case when the claims of inequitable conduct are made are the breach of the duty to submit prior art to the patent office. In the US, unlike many other countries, the applicants and all people involved into the prosecution of the patent applications bear the duty to submit all prior art they are aware of that is relevant to the patent application being prosecuted. And if the patent gets issued and gets and the judge, the court, finds out that some of the references, prior art references that the applicant was aware of were not submitted to the office, the judge may decide that that was made deliberately, that the applicant withheld those references on purpose to deceive the office, and that may lead to the unenforceability of the patent. The second one is false or contradictory statements made during prosecution of the U.S. Made during the prosecution of the patent application in the U.S. and even abroad. Basically, if the applicant made those false or contradictory statements, the court can decide that there was an attempt to deceive the patent office, and that may also lead to the unenforceability of the patent in question. And I'm sure there are other possible examples of inequitable conduct that may render the patent unenforceable. There was one recent case of, I think it was Gilead, maybe Casey could elaborate on that later. But this is a very unique and interesting concept. The other one is prosecution history estoppel. And that is the concept that says that everything that the applicant says during the prosecution of the patent application can and most likely will be used in the court if that patent gets to the court one day. And often it is used to limit the application of the doctrine of equivalence. That is when the court decides whether the features of the claims and the features of the accused, the allegedly infringing product are equivalent. The court will not only look at the common knowledge, right? Definitions in dictionaries or some scientific articles, maybe some testimonies, but also which are commonly referred to as extrinsic evidence, but also we'll look at the intrinsic evidence, and that is prosecution history. And if applicant said something during the prosecution that basically crosses off one of the some of the equivalents of those features, then the application of the doctrine of the equivalence may be limited. So be careful what you say during your prosecution. You don't want to make statements that will limit the scope of your claims. And also, there is an interesting concept of willful infringement. And that is if the if the court finds out that the patentee, that the accused infringer knew about the patent, and still continued to infringe it, then the court may increase the damages for patent infringement to up to 3 times. Those are essentially punitive damages, and they are referred to as treble damages. And at the EPO, all questions of inequitable conduct and unenforceability, of prosecution history, estoppel, and the doctrine of equivalence are remitted to national law. However, there is no duty to submit prior art at the EPO level. Same stuff as in Russia. We also don't have that duty. And generally in European countries, statements made during EPO prosecution cannot be used for claim construction, for limiting the doctrine of the application of the doctrine of equivalence. And there is no doctrine of inequitable conduct. And punitive damages are very rare in European jurisdictions. Thank you very much. I think I covered well, a lot of notable features that distinguish US from other countries, and I would be happy to answer your questions. Thank you.
Andrey, I'm sorry.
Yes.
I wanted to follow up on what you said about the Gilead case.
Yes.
You were just...
Guys, I'm so sorry to disturb you. Yes, thank you for sharing the screen. Yes, sorry, Casey.
Yes, to further your point, in that case, the misconduct was by a patent attorney who was negotiating with another business and learning confidential information of that company. This same attorney went and wrote patent applications to cover that technology, even though the disclosure was protected by non-disclosure agreements and a wall that said no information can be used for patent applications. That's what you're referring to, correct?
Yes, yes. I read this. I found out about this case when I was refreshing the presentation, and I found it is very interesting. It's a good addition to TheraSense and other cases. I think it's very interesting.
I have a more basic question for you. If a Russian company wants to patent its technology, what is the first step? Where do you start?
Well, you mean to patent it in the US or
yeah, in the United States, yeah.
Yeah, to ultimately get to the United States. But do you start in the United States, or where do you start?
Well, we file applications, and that is public information. We file applications in Russia, but they are drafted from the very beginning by U.S. patent practitioners. So it is easier to adapt and draft the application from scratch and adapt it to the U.S. and then translate it into Russian, and it's easier to make Russian application from US draft than the other way around. So I would recommend, if the company is planning to patent in the US, I would recommend to involve American patent attorneys, patent agents, patent practitioners from the very beginning of the process, right? To make sure that the draft that is made complies with all the numerous requirements of the US, or at least if you're drafting with Russian or European patent agents, make sure that the that there is a US patent agent that will review, maybe massage it a little bit before filing. Because it could be, many problems could arise. Many problems could arise from translation into from Russian into English, and sometimes we tried that several times, and sometimes it costs even more to translate and make sure everything is fine in applications originally drafted in Russian than to simply draft in English from scratch.
Thank you.